Good morning to all of you. Today we are going to discuss a case on medical negligence. Previously, I told you that in the law of torts, Mensrea as intent is not at all necessary. It is not at all an essential element in tort. Whereas in crime, Mensrea is a very good element. Mensrea, bad intention, guilty mind, all these things will come under criminal action. Yesterday, on 6th of this month, two judges bench, Justice A.M. Khanvilkar and Sanjeev Khanna, while disposing the SLP number 2395 and 2396 by 2021 in the case of Prabhat Kumar Singh versus State of Bihar and others, held that Mensrea is not at all an element in the law of torts. Whether guilty intention is there or not, but if any tortuous act is committed, definitely it is a tort. That too, this is a case of medical negligence. Of course, the complainant thought it criminal negligence and filed a private complaint. So here what happened is, the appellant, he filed a private complaint before the lower, that is a magistrate court, alleging sections 304, 316, read with 34 IPC. Remembering 304, culpable homicide not amounting to murder. That means where the murder has taken place, but when there is no intention, then it is 304. 316, it is causing miscarriage. So ultimately, so what happened is, it happened in the state of Bihar. So the relatives of this person having been taken to the hospital, so due to the medical negligence, they died and lot of damage was caused. Therefore, he filed a private complaint against them. So Supreme Court has clearly, what happened is, then later the Honorable Local Magistrate, he has taken it on file, and normally what they do is, they will endorse it to the police under section 156 clause 3 CRPC. They will forward the same for investigation by the police. But without endorsing the same, he has taken it on file and he has issued a process, that is summons to the accused persons. The accused are doctor, managing director of a hospital. Therefore, aggrieved by this, they approached the local sessions court, ultimately based High Court of Patna. But yes, the High Court of Patna also agreed that since there is no Mensrea, there is not at all any necessity to take the summons like that. They have given orders. So agreed by the orders, once again, now they have come to the Supreme Court. So this petitioner has filed a SLP in the Supreme Court, since the High Court has stated that there is no necessity for taking the summons. But his issue is that this has to be inquired into. So now the Supreme Court stated that, yes, definitely, in a case of tort, so the Mensrea or bad intention or guilty mind is not at all necessary. Therefore, inquiry should be conducted. But the point is, the complainant in this case, he has filed a criminal case in a criminal court. So criminal negligence he wanted to believe, but it is only medical negligence. Right. Now, Supreme Court placed reliance on the very famous case of Jacob Matthew versus State of Punjab 2005, which you can find in volume 6, SCC 1. There, in the case, in the discussion, lot of emphasis has been paid to differentiate between the criminal negligence and medical negligence. No doctor wants to kill a person normally by the virtue of his negligence. Since he did not take proper care, due to the breach of duty of care, something may happen, he is liable to pay compensation. So, in that connection, in Jacob Matthew case, they have given 3 points. Number 1, the magistrate should not automatically take such cases on file unless there is cogent evidence, unless there is a preponderance facts produced before the court about the negligence. Yes, they can take it. Normally, they should not take it on file. Number 2, whenever it is endorsed to the police officer, he should not be blindfolded. He should consult a medical team. He should consult a doctor, preferably in government service and particularly in that field. He should take an opinion whether there is medical negligence on the part of the accused persons or not. And then only he has to decide the case and he has to proceed with further investigation. Third point, do not haphazardly arrest the accused. Just like 498 cases, do not arrest the doctor, because the doctor's profession is also a life-saving profession, an important profession. So, suppose if you start arresting the accused, a doctor with shivering hands cannot conduct a surgery, is it not? They should be given protection also, no doubt. If there is negligence, yes, you have to take him to task. So, taking into consideration of these 3 points, since there is no cogent evidence to prove the facts, then the Honorable Supreme Court of India asked the complainant, that is Prabhat Kumar Singh, to produce evidence. So before the lower court, if the court is satisfied, then they can endorse to the police. If the police are satisfied, then they have to inquire the matter thoroughly and they have to file the pilot case. So definitely, if there is prima facie evidence to fix up the doctor to the criminal negligence or medical negligence, definitely they can give the summons and they have to attend the court. But till such time, they need not attend. But here, what they found fault with the High Court is, High Court simply said, since there is no mensrea, no necessary to take the summons. But here Supreme Court clarified that mensrea is not necessary in law of torts. This is a good judgment. Please read it and enrich your legal knowledge. Thank you very much.